Well, we all remember this bad acting DA, don't we? Monroe County, New York. She gets pulled over by a local cop for speeding, except for the fact that the pullover doesn't happen because she doesn't pull over. She keeps going. And she goes straight to her house. She never acknowledges him. Instead, she gets on the phone and she calls his supervisor and she says, "You need to tell your guys to back off." The cop follows her to her home, obviously, where she, right here in this photo, pulls into her garage and just goes about her thing as like, he's trying to give her a ticket. She's disregarding him. She's messing with her dog. She goes inside the house. He says, "Man, please come outside the house." It was a hot mess, you guys. If you have not seen the video, I'm attaching the playlist that I have on this woman in the description box below. So let's get to it. Rochester, New York area. So what is this woman's fate? Who was deciding this? Well, a special prosecutor was looking at her case. They did a whole investigative report. All right, let's go through some of these photos. She looks different there. This is where she gave her apology. "I'm so sorry. I'm so sorry. I was a horrible person. I recognize my errors." So freaking fake. This is where she's laughing in the cop's face and calling his supervisor all at the same time. And she says to the cop, believe it or not, guys, she says to the cop, "It doesn't matter because I'm going to be the one prosecuting this anyway." Really, mama? Okay. The police department, they were in an uproar. A lot of people were in an uproar because of the way that she handled herself during this. I mean, she's the district attorney of that county, you guys. She's supposed to be a partner. She's supposed to be working with the police department. And, for all we know, she may not have even gotten a ticket if she'd have pulled over. But he was a very well-mannered officer, and I have the utmost respect for the way he treated this whole situation. A lot of people were upset, and they were saying, "You know what? If it had been anybody else, they would have been arrested. Why wasn't this woman arrested?" Well, I kind of agree. She should have been. But you can't just go around arresting the DA. You got to, what would happen if they did that? They can't do that. So, of course, supervisors got called in. Their supervisors called their supervisors who called their supervisors. I mean, it was just a hot mess. What are we going to do? Because this is really like this for this county. This was a PR nightmare, okay? So what they did was they sent this whole investigation off to a different county to look at it, which, smart move. Let's find out what really is going on here. So a special prosecutor has now declined to file additional charges against Monroe County District Attorney Sandra Doorley following a traffic stop at her home. So here's the deal. The special prosecutor who was looking at this has declined to file additional charges. Now, when I say additional charges, that is because she did get a ticket that she had to pay. Onondaga, I'm going to say Onondaga County District Attorney William Fitzpatrick was assigned to review the case. In a letter to New York State's 7th Judicial District, Administrative Judge William Taylor, Monroe County Board of Ethics Chairman Jansen McNair, said he declined to file additional charges. It says, following an investigation by the Monroe County Board of Ethics, which, by the way, she's part of that, but she wasn't able to be involved with this actual ruling or investigation itself, but she is part of the ethics committee. In the Office of Public Integrity, Fitzpatrick was asked to determine whether Doorley should face additional charges. Despite initially electing not to pursue the requested report, Fitzpatrick released a letter Tuesday laying out all the possible charges that could have been given following this traffic stop and explains how they aren't applicable today. Fitzpatrick writes, District William Fitzpatrick to the Honorable William K. Taylor, Supreme Court Justice. And it says, Dear Sirs, on July 22nd, 2024, District Attorney Sandra Doorley submitted a request via affidavit to Monroe County Supreme Court Justice William Taylor for the appointment of a special district attorney under Law 701. This request was precipitated by a report from the Monroe County Board of Ethics dated July 18th of 2024, dealing with DA Doorley's conduct during and subsequent to an April 22nd, 2024 police encounter, which resulted in the issuance of a speeding ticket to Ms. Doorley. On page 16 of the Board of Ethics report, it is stated, We believe that the due application for the appointment of a special district attorney would prove an important element of District Attorney Doorley's continuing commitment to her efforts to restore the public's trust in her. Although not specifically delineated in the order appointing me as a special district attorney, I have undertaken as my mission to answer the questions raised on page 16 of the board's report, namely, whether further investigation of any potential charges emanating from her, D.A. Doorley's, conduct may be possible or warranted at this point. The report alludes to interviews conducted by investigators both from the newly formed New York Commission on Prosecutorial Conduct and the Monroe County Office of Public Integrity with the arresting officer Cameron Crucifilli and Lieutenant Jeffrey Webster, both of the Town of Webster Police Department. In those interviews, page 16 of the board's report, both officers believe that D.A. Doorley could have been charged with obstructing governmental administration. And Officer Crucifilli believed the DA could have been charged with violating Vehicle and Traffic Law Section 1144A, a traffic violation. I am not limiting myself to consider only the offenses mentioned by the two officers. I am also not charged with determining whether or not a violation of the canons of ethics has occurred. I am not efforting to conduct extensive interviews, as in my judgment, the Board of Ethics review and the OPI review were thorough and balanced. There is little mystery as to what occurred in this highly documented matter. On April 22nd of 2024, D.A. Doorley was speeding at 55 miles per hour in a 35 mile per hour zone. A diligent police officer activated his emergency lights and attempted to pull her over. The DA failed to pull over and proceeded approximately 1 mile to her home, where she was confronted by the pursuing officer. D.A. Doorley made 3 phone calls to the Webster Police Chief, Dennis Kohlmeyer. There was approximately 25 minutes of verbal interaction between the pursuing officer and D.A. Doorley, joined by Lieutenant Webster and a Sergeant Johnson, the majority of said dialogue being captured on Officer Crucifilli's body-worn camera. I will discuss the dialogue further in this report. D.A. Doorley was issued a speeding ticket to which she pled guilty and paid a fine. And finally, this matter has received extensive media coverage on a local, state, and national level, and it's been investigated by the Monroe County Board of Ethics and the Monroe County Office of Public Integrity, and I will be examined by the Bar Association Grievance Committee and the New York State Commission on Prosecutorial Conduct. It's now being examined by me solely to determine if additional charges are appropriate against D.A. Doorley. I think it would be appropriate to explain exactly who I am and my mindset in reviewing this matter at the direction of Justice Taylor. I am the son of a New York City police detective, so I have had intimate contact with police work for quite a long time. I started an intern with the Onondaga County District Attorney's Office in 1975. I became an assistant district attorney in that office in 1977 and remained there until the end of 1986, having achieved the rank of Chief Assistant DA. In charge of the Homicide Bureau, the youngest person ever to hold that position. I was in private practice for 5 years until I ran for and was elected district attorney in 1991 and have held that office to the present day, having been reelected 8 times. I have served as president of the New York State DA's Association and president of the National DA's Association and continue to serve as a board member of both organizations. I have created within both organizations a best practice committee with an emphasis on ethics training, a model that's now copied in 30 other states. I have been honored as a prosecutor of the year both by the New York State DA's Association and the New York State Bar Association, and recently received the New York State District Attorneys Association Frank Hogan Award, its highest honor for prosecutorial excellence. I have known DA Sandra Doorley for many years and considered her a colleague and a friend, and have made very clear to her and her attorney that my reputation is far more important to me than any fealty I have for the DA, and that my review of these facts would be objective and done without fear or favor to anyone. I think it is prudent at this point to discuss what exactly it is that a prosecutor is charged with doing. In a word, it's justice. That word may be subject to myriad interpretations, but when all is said and done, a prosecutor's job is to hold offenders accountable, protect the public, prevent crime, and promote preventative measures, be open and honest both with the court and with the defense counsel, to never seek prosecution of even an arguably innocent person. In short, to some of us, it's the greatest job in the world. A prosecutor belongs to the only profession whose members wake up each morning and think of ways to put themselves out of business. We derive as much as professional satisfaction by exonerating the innocent as we do in convicting the guilty, and we recognize that our greatest asset or weapon, depending on one's point of view, is our discretion. Does a prosecutor seek or not seek the death penalty? Do we divert an offender to a specialty court or keep him or her out of the system? Do we pursue a top count conviction in adult court or consent to having a juvenile referral to family court? And the task now before me, does a prosecutor recommend more charges against a possible offender based on a review of these facts and a consideration of the overall situation? When making that latter decision, amongst other things, this prosecutor considers the following. Number one, the available evidence of guilt to ethically sustain a charge. Is there proof for a conviction beyond a reasonable doubt after trial? Are there any legal impediments to a prosecution? 2. The harm caused by the alleged conduct. 3. The effect of charging or not charging upon the public's faith and trust in the criminal justice system. 4. The background of the possibly accused, the likelihood that he or she will reoffend, and has the subject recognize the inappropriate nature of his or her conduct and shown remorse. Let me outline my analysis of the case, going through each of the 4 criteria listed in sequence. 1. The evidence or lack thereof of guilt of any uncharged crime, any impediments to further charges. D.A. Doorley in this case was speeding. She failed to adhere to a lawful attempted police stop. She called the local police chief. She retreated to her home and failed to follow police commands. She was disrespectful and profane to the pursuing officer. She accepted a UTT for speeding and pled guilty to the charge and paid a fine. Let's look at possible infractions that could have been charged on April the 22nd, 2024 by the Town of Webster Police Department, starting with V&T violations. The first possible charge, of course, is speeding. And me having a grasp for the obvious, this is what Officer Crucifulli charged her with and to what she pled guilty. There are significant legal ramifications to that. Remember, I am being asked to determine whether additional charges are appropriate today, not on April 22nd of 2024. Significantly, Officer Crucifulli acknowledges that he is exercising his discretion in issuing the ticket, and he several times alludes to considering other charges, including arrestable offenses, although he does not indicate at that time what they might be. In New York, officers have summary arrest powers, and once those decisions are made, they are in no way binding on a prosecutor. He or she may dismiss, upgrade, or downgrade the charges in exercising prosecutorial discretion. Secondly, Officer Crucifulli opined that he believed a violation of Section 114 of the V&T law could have been made. This is incorrect. That section is the so-called pullover law that is inapplicable to these facts. Thirdly, there is V&T law 1102, which reads in a relevant part, no person shall fail or refuse to comply with any lawful order or direction of any police officer. Officer Crucifulli would clearly have been justified in issuing an additional UTT to D.A. Doorley based on her alleged failure to comply with his lights and siren. Whether D.A. Doorley's assertion that she thought he was following someone else is believable would be a credible determination for the local magistrate hearing the case. In any event, this discussion is moot, as D.A. Doorley has pled guilty to the speeding offense, rendered a prosecution for 1102 impossible due to double jeopardy, which may bar all potential prosecution in this case, as we will discuss later. Y'all, don't you think she knew that when she paid that ticket? That was why she was trying to get it paid so quick. I think so. I now begin a review of the possible penal law charges that may have been brought against D.A. Doorley for her conduct on April 22nd of 2024. Penal Law 270.25 deals with a motorist fleeing a lawful police stop. I'm going to butcher this man's name, and I don't mean to. The law was passed after Trooper Craig Tadashini was killed in a crash while pursuing a motorcyclist who refused to pull over and was traveling well in excess of 100 miles per hour. The actions of D.A. Doorley on April the 22nd of 2024 do not remotely compare to the statutory requirements of Penal Law 270.25. Further, as Webster Police Captain Mark Reed stated to investigators, this was not a pursuit. And Officer Crucifulli acknowledged that D.A. Doorley's vehicle did not increase speed or drive recklessly, and in fact slowed down once it pulled onto a street. where the DA resides. The next potential charge I considered was official misconduct in violation of Penal Law 19500, a Class A misdemeanor, which requires a public servant, here the DA, with intent to obtain a benefit, not being charged with a traffic offense, to commit an act relating to her office, but constituting an unauthorized exercise of her official functions, knowing that such act is unauthorized. In this case, there is no evidence to support an assertion that D.A. Doorley committed an act related to her office. Viewing the evidence in a light most unfavorable to the DA, she tried to talk herself out of a ticket, unsuccessfully as it turns out. I've never seen a prosecution, nor have I prosecuted a case like this myself, for official misconduct under facts even remotely similar to this. Having served by gubernatorial appointment as co-chair of the Moreland Commission to investigate public corruption, I say with a high degree of certainty that no ethical prosecutor would treat these facts as official misconduct. That leaves, finally, a possible charge of obstructing governmental administration in violation of Penal Law 195.05, a Class A misdemeanor. Sometimes during the exchanges recorded on the body-worn camera, Officer Crucifulli refers to arrestable offenses. Under the new criminal justice reforms, none of the considered offenses are arrestable under CPL 150.20 and Court of Appeals decisions. Technically, the issuance of a UTT or an appearance ticket is an arrest, but I interpreted Officer Crucifulli's comments as suggesting the DA could have been physically placed in custody, which was not a legal option. Obstructing governmental administration. Is there proof of obstructing governmental administration? And are there viable defenses to such a charge so as to mitigate against making a charge? The relevant elements of OGA in the second degree are as follows. A person is guilty of OGA in the second degree when that person intentionally obstructs, impairs, or prevents the administration of law or other governmental functions, or prevents or attempts to prevent a public servant from performing an official function by means of intimidation or interference, or by means of any independently unlawful act. In layman's terms, was there proof sufficient to sustain an arrest and a conviction that D.A. Doorley attempted? Obviously, in light of the fact that a ticket was issued and a plea was entered to speeding, I can only consider an attempt when envisioning possible criminal conduct to prevent Officer Crucifulli from issuing her a UTT for speeding or an appearance ticket for some other charge. So let's consider the evidence, arguable or otherwise, that she did so during the 25-minute post-speeding encounter with Officer Crucifulli. D.A. Doorley's treatment of the officer was demeaning and unprofessional. She was profane, referred to him as an asshole. She reached out to the chief, Officer Crucifulli's supervising officer, and put the officer on the phone with the chief. A reasonable observer could easily conclude that the only purpose for this interaction was to have Chief Kohlmeyer convince Crucifulli to back off and drop the whole affair. It would not be an abuse of police discretion to have issued an appearance ticket for OGA had that been done on April 22nd of 2024, even though that would have been a stretch. Here is why I believe it would be an abuse of my prosecutorial discretion to issue such an appearance ticket today. Initially, there's a serious question about double jeopardy. Ultimately, this would be a legal question to be decided by a court, and based on case law I have reviewed, I don't know how a court would rule. Many times a prosecutor is faced with the dilemma of upgrading charges, but faced with the logistical problem of not having completed an investigation. For example, a defendant is speeding and causes the death of another motorist. The driver refuses a breath test and does not exhibit sufficient common law indicia of DWI to warrant an arrest. The local police agency issues the driver a ticket for imprudent speed or some other traffic infraction. Meanwhile, the prosecutor is considering homicide charges but is awaiting an accident reconstruction, blood test, review of the driver's whereabouts before the accident, blood work of the deceased, and multiple other factors. So what my office would do is to file a notice under CPL 170.20 precluding the local court from taking a plea to the traffic charge and thus preventing double jeopardy. No such move was done in this case, which is understandable as no special prosecutor was appointed, which in hindsight may have been a prudent action. Note that DA Doorley almost immediately attempted to have her conduct reviewed by a fellow DA and has self-reported herself to the Bar Association. However, the defendant in this case, DA Doorley, signed the ticket pleading guilty on April the 23rd of 2024 and forwarded it to the Webster Town Court on that date. Due to recusals, the defendant's plea was not accepted by a visiting judge until May the 7th of 2024. Had some appropriate official in Monroe County or officials of the town of Webster PD been concerned about additional charges, this almost 2-week delay would have provided ample opportunity to address this concern and have the county attorney or the town attorney approach the court in Webster. This was not done. I emphasize that a double jeopardy argument may have been successful, which obviously means it may have been denied. If one assumes, and I don't base prosecution on assumptions, that DA Doorley corruptly attempted to influence Officer Crucifulli to deep six the ticket, she clearly has established a defense of renunciation under Penal Law 40.10. Assuming again that DA Doorley wanted to get out of a ticket and called the chief to enlist his aid, belittled Officer Crucifulli to intimidate him, flashed her badge to further her goal, none of that supersedes her renunciation of any such scheme within 6 minutes of physically encountering Crucifulli. On multiple occasions, DA Doorley says, sometimes in a profane way, just to give her the ticket. Her assertion that she will in some way fix the ticket herself is absolute gibberish. No one seriously believes that the DA was going to prosecute the case herself and dismiss it, and thus have her career ended by a gubernatorial removal or an action by one of the several bodies investigating her conduct. There is one telling moment where Sergeant Johnson, exasperated with her conduct, says, "What do you want us to do? Not do our job because it's you?" The DA's immediate response is, "No, write me a ticket." This is recorded by Crucifulli's body-worn camera from a distance while Johnson is talking to Doorley in her garage, and it's far from certain that they knew they were being recorded. To me, this is a clear renunciation, assuming there ever was an intent to obstruct, as a prosecutor and defense counsel could have. With that evidence, the filing of a misdemeanor information on this date would be totally inappropriate. Finally, there is no evidence of a physical act required by law by DA Doorley to obstruct, particularly when we are talking about a ticket that was issued, followed by a plea of guilty. Let me add that most prosecutors are not looking for more cases to charge. While I in no way condone it, most people stopped on a highway by a police officer spend the first several moments of the encounter trying to talk the cop out of issuing a ticket. This has been ongoing in the U.S. since at least 1899, when New York City taxicab driver Jacob German was cited for driving 12 miles per hour in an 8-mile-per-hour zone. It's not clear if German tried to talk his way out of a ticket, but he was imprisoned anyway. I have no desire to add several hundred OGA cases to my docket. 2. Harm caused. Getting to the second of 4 areas I consider, let's assume a prosecutor disagrees with me and thinks an OGA charge is appropriate. Putting myself in that person's shoes, despite the erroneous nature of that conclusion, I ask who has been harmed. Well, certainly Officer Crucifulli was treated unprofessionally. He, however, stayed true to his oath. He observed a speeder and he gave her a ticket. He made a decision, appropriate in my judgment, that exercising his discretion, he felt that a sole charge was appropriate under the facts of this case, and I agree. Certainly, the citizens on Phillips Road don't want speeders in their neighborhood. My concern, however, is about actual, not potential harm. The taxpayers of Webster are undoubtedly not thrilled by multiple officers responding to a speeding ticket that was precipitated by the DA's conduct. But that harm is ephemeral and does not, in my mind, rise to the level of warranting an additional charge. 3. Public confidence. Few people truly understand the role of a district attorney and the impact of that position on people's lives. No one is especially worried about the DA until his or her daughter is murdered. I have understood this for most of my professional career. A community has to trust its DA and have confidence that no one is above the law, that all are treated equally before the bar of justice. I am not oblivious to the fact that the Monroe County community is disturbed by the conduct of DA Doorley. She was speeding in her company car. She was rude and demeaning to a cop who goes out every day to protect us. She, in my own terms, screwed up royally. There is a lot of healing to do in Monroe County. It is my judgment no one is more aware of that than DA Doorley. Both reports acknowledge that she has taken efforts to restore that trust. I am aware that some who read this report will never have trust restored because they never trusted her to begin with. Some will feel betrayed or let down. Ultimately, absent some action by the remaining investigators, the voters of Monroe County will make a decision about their confidence and trust in DA Doorley. It's axiomatic that one does not serve for over 3 decades as a prosecutor without acquiring some enemies, as well as numerous friends. It is a job that virtually everyone with a keyboard knows how to do better than the DA herself. When considering whether my decision will impact the public's trust in the system, I exclude the opinions of those who think a DA can do no wrong. I also exclude those who feel that state prison is too lenient, even after she was tarred and feathered. By all accounts, from reviewing the 2 thorough reports provided to me, this was an aberration in the DA's conduct. She works in a high-stress job. That stress compounded in this instance by a rash of homicides, the death of a friend, and a health scare regarding her husband. But as Officer Crucifilli said, referring to his role as a police officer, we have bad days also. He also summed it up best in his decision to not file further charges, sustainable or not. And in pursuing his duty, I'm sorry that you had a bad day, and I'm sorry that it went this way, but I do respect what you do. Perspective is always important for a prosecutor, and I hope for any reader of this report as well. Which brings me to my final criterion in deciding whether or not to bring charges. Background of the accused. Please understand that the phrase prosecution is multifaceted. There is a crime, an investigation, a collaboration between police and prosecutors. There is analysis of forensic evidence. There may be an arrest, an arraignment, assignment of counsel, bail argument, further investigation, a grand jury presentment, if an indictment, a further arraignment, and bail argument, motions and discovery, pretrials, plea bargain offers and acceptance or rejection, jury selection, trial, verdict, post-trial motions, appeals. So when someone says, will you prosecute this case, it is a nuanced question. Do you mean, will I arrest someone, try them, try to put them in jail? When those issued are weighed by an experienced prosecutor, the background of the accused is always taken into consideration. Is it a first offense? How badly was someone hurt? Is the accused repentant? Likely to offend again? A person of good character? Someone who abused his or her authority? An elected official held to a higher standard? In this case, which has been examined by multiple agencies and more to come, the facts are little in dispute. An elected district attorney was speeding home and captured on a radar by a police officer doing his job. Rather than pulling over, she proceeded to her home and parked in her garage. The pursuing officer engaged her in conversation about her failure to pull over. She disparaged him with vulgarity and the air of privilege by virtue of her position. Finally, she got a speeding ticket, pled guilty, and paid a fine. This was unprofessional, it was wrong, it was completely avoidable and unnecessary and way out of line for Monroe County's chief law enforcement officer. On the other side of the scale is a 3-decade public servant rising from the rank of assistant district attorney to be the elected district attorney of Monroe County, one of the largest counties in New York State. Regardless of one's opinion of the DA, regardless of one's opinion of her conduct on April 22, 2024, and regardless of one's opinion of prosecutors or police in general, DA Doorley's prior service, which by all accounts has been exemplary, matters. I know, and DA Doorley, who along with her attorney cooperated fully with me in my review, knows that a prosecutor needs to be held to a higher standard. It's part of the job, but I'm not going to further pursue charges and disregard who she is and sacrifice her career on the altar of making an example out of her by bringing unsustainable charges. If you seriously don't think she knows she screwed up, that she's been embarrassed and suffered a blow to her stellar reputation, well, you haven't been paying attention. Based on all the above, I decline to authorize the filing of any additional charges against DA Sandra Doorley, and frankly, I cannot remotely imagine an ethical and competent prosecutor determining otherwise. I will consider my assignment as Special District Attorney terminated unless advised to the contrary by Justice Taylor. Sincerely, William J. Fitzpatrick, District Attorney. I think that he writes beautifully, first of all. I like the flow of his writing. I get where he's coming from. He laid out all the facts. He weighed everything out. And it's true. If you don't like her, you don't like her. But honestly, at the end of the day, I think it's the double jeopardy thing. Had that not been in play, something more may have happened. But because she is the DA and she does know the law, she went as quickly as she could to pay that ticket and plead guilty, to put that double jeopardy in play. So with that being said, the rich keep getting rich, the privileged keep getting more privilege, and we have homeless veterans living on our streets. We have people in power all over our nation, different sides of the fence on everything, taking care of other people outside of our own communities, paying the people that have the power to get what they need to keep their power, if that makes any sense. Our entire country has set an example that they would rather feed the hungry in other nations and step over the homeless guy that they have to walk past to work every day. And it's just a fact. And most of you guys that are watching this, maybe even all of you guys that are watching this, you don't live in this county. This really doesn't affect you. But it's just another example of how those in authority can always find somebody else in authority to back them. Beautifully written, beautifully said. And he made some great points. But she should have stepped down. She should have stepped down. But the people are going to speak. When she goes up for re-election, the people will speak, and she will be out of a job. So, because you know what, the last time that I remember, last time I recall that I was pulled over and I got a ticket, it didn't matter what I had been doing at work that day. It didn't matter if I had gotten in trouble by a boss. It didn't matter if I was crying. It didn't matter, things going on in my personal life. That doesn't matter, because that had nothing to do with the fact. And the fact was that I was speeding and I was breaking the law. And unfortunately, in the country that we live in, sometimes those traffic stops can get really dangerous depending upon the color of your skin. And that is a sad, sad fact. And on the other side of it, we have some amazing officers out there protecting our communities every single day. So, with that being said, I'm going to now step down from my soapbox, and I will let you decide how you feel about it. And comment down below. Y'all have a blessed day, and I will talk to you very, very soon.